So the state of California is once again playing their gun control game, and they're asking for the Ninth Circuit en banc panel to uphold their statewide ban on magazines based on a recent decision in Maryland dealing with assault weapons. Now, really quick before we jump into this video, if you agree that magazine bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Kershaw Knives. Kershaw makes amazing knives. I carry their knives every single day for my EDC. I carry their Kershaw Iridium knife and then also their Bel Air, a company that's been supporting the channel for a long time, that supports 2A content and just also wants to give you guys quality knives. So if you're interested, check them out. And if you use the code ARM40, you can get 40% off of your order. Now, as I mentioned in the intro, in this video, I have a very important update for everyone in California who's been asking about the California magazine ban case Duncan versus Bonta. You may recall that recently a Ninth Circuit en banc panel decided to break a ton of their rules and then decided to take this case as a comeback case, take this out of the hands of the lower court there, a 3-judge panel, take the case immediately to essentially try to uphold what California is doing with their magazine ban. California now argues that the Bianchi case out of Maryland actually supports what they are doing here in California with their magazine ban, and essentially they're submitting it as evidence for why the Ninth Circuit should rule in their favor. But now the plaintiffs in this case have filed their response to that, showing that that Bianchi case, if followed here, will simply just lead to a new backdoor means and scrutiny approach that has already been rejected by the Supreme Court. And so if the Ninth Circuit en banc panel follows what the Fourth Circuit did in Bianchi, it's going to lead to a type of analysis and a precedent that the Supreme Court has already rejected, which in some ways might actually be good for us, because then it primes this case for actual Supreme Court review, because again, you would have a Ninth Circuit, a lower court, directly defying what the Supreme Court said in Bruin. Now, for those not aware, Duncan versus Bonta involves the California possession and purchase ban on so-called large capacity magazines, or simply any magazines that hold more than 10 rounds. This was a case that originally was submitted in a lower court in the Southern District of California in front of Roger T. Benitez. And on original review, Benitez ruled that this statewide ban on magazines was in fact a violation of the Second Amendment. Now, of course, after his original decision, the state of California, of course, appealed up to the Ninth Circuit, and it was reviewed by the same Ninth Circuit en banc panel that's now reviewing the case as well. And they issued a decision essentially upholding this statewide ban on magazines. Now, after that loss, the plaintiffs here then submitted this case to the Supreme Court, and they asked for the Supreme Court to grant review to the case, but the Duncan case was put on hold behind Bruin. And after the Supreme Court issued their 6-3 decision in Bruin, this Duncan case was then granted, vacated, and remanded back down to the Ninth Circuit. But at that time, the Ninth Circuit did not want to review this case at all, so they decided to kick the can all the way back down to Judge Benitez. But of course, Judge Benitez on re-review simply reaffirmed what he said before, but of course, California is not going to take that loss, so then they appealed once again up to the Ninth Circuit. But here's where things got very interesting in this case. The same Ninth Circuit en banc panel, the same makeup of judges, decided to take the Duncan case as a comeback case. And in doing so, they broke a ton of the Ninth Circuit's procedural rules to take the case, and they did that to essentially prevent any positive 2A ruling. But like I said, ultimately the Duncan case was then submitted to the Ninth Circuit en banc panel because they took it as a comeback case, and then it was argued back in March. Just recently, the state of California submitted a supplemental letter of authority, essentially arguing now that under Rahimi, Judge Benitez actually erred in his analysis. California argues that under Rahimi, California should win the case because they presented, in their eyes, sufficient historical evidence to actually support this ban. And so in this letter, California states that Rahimi reiterated that the right secured by the Second Amendment is not unlimited, does not sweep indiscriminately, and is not a right to keep and carry any weapon whatsoever. The court recognized that some courts have misunderstood the methodology of Bruin and Heller, which were not meant to suggest a law trapped in amber. California goes on to argue that in Rahimi, it criticized the Fifth Circuit and the dissenting justice for committing the error of reading Bruin to require a historical twin rather than a historical analog. They argue that that is the same error committed by the district court in this case. And so under Rahimi, the state of California argues that Judge Benitez was too restrictive when he looked at this case, that he required too much of a narrow historical approach. He was requiring a historical twin or a historical analog. And essentially California is arguing for the third time this case should be submitted back down to Judge Benitez for him to re-review it and I guess take a more broad historical approach. So also now, like I mentioned, they have submitted the Fourth Circuit en banc panel's decision in Bianchi, and they're trying to use that rifle ban case as further support for why the magazine ban should be upheld. California argues that the Fourth Circuit considered a Second Amendment challenge to a Maryland law banning assault weapons after rejecting plaintiffs' facial challenge because of plaintiffs failed to show that each firearm regulated by Maryland statute is within the ambit of the Second Amendment. The court considered the constitutionality of Maryland's restrictions on AR-15s. The court applied Bruin's two-step methodology and concluded at the first step that the covered firearms are not within the scope of the constitutional right to keep and bear arms for self-defense. So California is trying to use the recent Bianchi improper military use analysis to essentially uphold this magazine ban in California. Now, also in Bianchi, the Fourth Circuit en banc panel argues that in their belief, AR-15s and similar rifles are essentially useful in military service, and since they are militaristic weapons, a state can just outright ban them. They can put restrictions on them because they are dangerous and unusual. The Fourth Circuit also relied heavily on public interest arguments and approaches. Essentially, they tried to backdoor in a type of analysis that was already rejected by the Supreme Court in Bruin and also in Rahimi, but still you have California advocating for the same type of approach when it comes to this Duncan case, essentially arguing that public interest should outweigh everything and the public interest would weigh in favor of essentially banning these types of magazines. But now you have the Duncan plaintiffs who have also filed their response arguing that if that Bianchi case is followed here in Duncan, that would simply lead to a just new type of means and scrutiny, a type of decision that has already been expressly rejected by the Supreme Court. And that would be a huge error and essentially would just be outright defiance once again by the Ninth Circuit. The plaintiffs argue in their response that the Attorney General's short summary of Bianchi lays bare the fundamental problems with that decision. As the Attorney General dutifully recounts, the Fourth Circuit held that states may ban any and all arms that, in legislators' and judges' view, have an inordinate toll on public safety and societal well-being, provided that states preserve avenues for armed self-defense. That is just means and scrutiny by another name. Asking whether conduct has had an inordinate effect on societal well-being is no different from asking whether a state has a strong enough interest in restricting that conduct. And asking whether a law leaves sufficient avenues for armed self-defense is just another way of asking whether a law burdens more constitutionally protected conduct than necessary to serve that state's interest. None of that is consistent with the Supreme Court's directives. Bruin was not an invitation for lower courts to do everything just the same as before, but with some new window dressing. When the Supreme Court rejected means and balancing as one step too many, it took out of the hands of the government the power to decide what the people really need for their own self-defense. Courts must now assess whether a law is consistent with the nation's historical tradition of firearms regulation. They cannot circumvent that mandate by purporting to locate in that history the very means and balancing that Bruin rejected. The Fourth Circuit's decision flies in the face of that principle. In stark contrast, the District Court's decision in this case carefully and correctly applied the lessons of Bruin. This court, the Ninth Circuit, should affirm. What the plaintiffs in Duncan are simply pointing out is that what California is advocating for is just simply a new type of disguised means and scrutiny. They are still putting forward the same arguments, but they are kind of changing the window dressing like they claim, and they're simply just trying to change the approach enough, hide it behind the nuanced approach language argued in Bruin and Rahimi, just hide it enough within the language of those decisions, but still trying to reach the same approach of a claimed public interest that should outweigh everything, and simply the state should be deferred to whenever they have this claimed public interest. So that's what's going on in the California magazine ban case. California is now trying to use the Bianchi Maryland rifle ban case to support what is going on in California. So if anything else develops, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All of those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.